reading BARBRI's Commercial Outline, Criminal Law, page 1. Just the introduction, nothing special. Now we're in jurisdiction and general matters. Jurisdiction. As used in this section, jurisdiction means the authority of a sovereign to create substantive criminal law. The authority of a court to enforce criminal laws is also an aspect of jurisdiction, but is more properly treated as a matter of criminal procedure. 1. Federal criminal jurisdiction. The power of the federal government to create crimes falls into the following broad categories: power over federally owned or controlled territory, power over conduct occurring within a state, power over United States nationals abroad, and power over conduct on ships or airplanes. So, do we need to go into that? No. Situs of a crime. At common law and in those states that have not expanded jurisdiction by statute, only the state in which the situs of the crime is located has jurisdiction over the crime. Situs is generally defined as a place where the prescribed act or omission takes place. If the crime is defined in these terms, or the place of the harmful result, if the crime includes a result as a material element. Example: a libelous statement may be made a crime where it is published, not where it is written, because the crime of libel prescribes the act of publication rather than the act of writing the libelous statement. True. Modern basis for jurisdiction. A person is subject to prosecution in a state for an offense that he commits within or outside that state by his own conduct or that of another, for which he is legally accountable under the following conditions: 1, 2, 3, and 4. When the offense 1 is committed wholly or partly within the state includes occurrences within the state of either Romanet 1, conduct that is an element of the offense, or Romanet 2, a result constituting such an element. Example: in homicide, the result is either the physical contact causing death or the death itself. Or 2, when there is conduct outside the state that constitutes an attempt or conspiracy to commit an offense within the state, plus an act inside the state. Or number 3, when there is conduct within the state constituting an attempt, solicitation, or conspiracy to commit in another jurisdiction an offense under the laws of both the state and such other jurisdiction. Or 4, when an offense based on the omission of performance of a duty imposed by the law of a state is committed within that state, regardless of the location of the offender at the time of the omission. Part B, sources of criminal law. Common law crimes. 1. A common law crime is one created and enforced by the judiciary in the absence of a statute defining the offense. A. No federal common law crimes. Federal criminal law is governed entirely by statute. Although there are no federal common law crimes, Congress has provided for common law crimes in the District of Columbia. B. Traditional approach. Common law crimes retained from the colonial period forward. American criminal law included the English common law of crimes unless repealed expressly or implied by statute. C. Modern trend. Common law crimes abolished. In recent years, a great many states have enacted comprehensive criminal code, and in doing so, most have abolished common law crimes, either explicitly or by implication. However, jurisdictions that have abolished common law crimes have not necessarily abolished common law defenses to crime, such as insanity and necessity, where their status do not expressly provide for these defenses. Constitutional crimes. The Constitution defines treason as levying war against the United States, adhering to enemies of the United States, or giving them aid and comfort. No person can be convicted of treason unless two witnesses testify to the same overt act or unless the defendant confesses. Okay, administrative crimes. A legislature may delegate to an administrative agency the power to prescribe rules, the violation of which may be punishable as a crime. Note, however, that the legislature may not delegate the power to determine which regulations shall carry criminal penalties, nor may it delegate the power of adjudication, i.e., the determination of guilt or innocence. With the proliferation of administrative agencies, this source of criminal law is becoming increasingly important. For example, violation of the anti-fraud rules adopted by the SEC may result in severe criminal liability. Fourth, the Model Penal Code. Although not a source of law, the Model Penal Code was a scholarly endeavor to compile a comprehensive and coherent body of criminal law. Since its publication in 1962, the Model Penal Code has greatly influenced the drafting of state criminal statutes. Due to its enlightened position on many different issues, the Model Penal Code may be the single most important source of general criminal law. C. Theories of punishment. Historically, several theories have been advanced to justify criminal punishment. We have 1, incapacitation, and in parentheses it says restraint. While imprisoned, a criminal has fewer opportunities to commit crimes causing harm to society. So, the second theory of punishment is special deterrence. Punishment may deter the criminal from prohibiting future crimes. General deterrence. Punishment may deter persons other than the criminal from committing similar crimes for fear of incurring the same punishment. Retribution. Punishment is imposed to defend society's sense of outrage and need for revenge. Rehabilitation. Imprisonment provides the opportunity to mold or reform the criminal into a person who, upon return to society, will conform her behavior to societal norms. In education, the publicity attending the trial, conviction, and punishment of some criminals serves to educate the public to distinguish between good and bad conduct and to develop respect for the law. That one's a stretch. Anyway, D, classification of crimes. At common law, all crimes were divided into 3 classes: treason, felonies, and misdemeanors. Several additional means of classifying crimes are now frequently employed either by the court or by state statutory schemes. You have 1, felonies and misdemeanors; 2, malum in se and malum prohibitum; infamous crimes, 3, and 4, crimes involving moral turpitude. Most states now classify as felonies all crimes punishable by death or punishment exceeding 1 year, such as modern schemes. Misdemeanors are crimes punishable to imprisonment for less than 1 year or by a fine only. At common law, the only felonies were murder, manslaughter, rape, sodomy, mayhem, larceny, robbery, arson, and burglary. All other crimes were considered misdemeanors. Malum in se and malum prohibitum. A crime, malum in se, wrong in itself, is one that is inherently evil, either because criminal intent is an element of the offense or because the crime involves moral turpitude. By contrast, the crime malum prohibitum is one that is wrong only because it is prohibited by legislation. So, for example, battery, larceny, and drunken driving are mala in se, whereas hunting without a license, failure to comply with the Federal Drug Labeling Act, and driving in excess of the speed limit are mala prohibita. 3, infamous crimes. At common law, infamous crimes are all crimes involving fraud, dishonesty, or the obstruction of justice. Under modern law, this concept has been expanded to include most felonies. 4. Crimes involving moral turpitude. The concept of moral turpitude, committing a base or vile act, is often equated with the concept of malignancy. Convicted of a crime involving moral turpitude may result in the deportation of an alien, the disbarment of an attorney, or the impeachment of a trial witness. Principle of legality, void for vagueness doctrine. The Due Process Clause of the Federal Constitution, found in the 5th and 14th Amendments, has been interpreted by the Supreme Court to require that no criminal penalty be imposed without fair notice that the conduct is forbidden. The void for vagueness doctrine, which has been held to require particular scrutiny of criminal statutes capable of reaching speech protected by the First Amendment, incorporates 2 considerations. 1, fair warning, and 2, arbitrary and discriminatory enforcement must be avoided. So, under fair warning, a statute must be given a person of ordinary intelligence fair notice that his contemplated conduct is forbidden by the statute. And 2, arbitrary and discriminatory enforcement must be avoided. A statute must not encourage arbitrary and erratic arrests and convictions. F. Constitutional limitations on crime creation. In addition to the constitutional requirement that a criminal statute be sufficiently specific to provide fair warning and prevent arbitrary enforcement, Article 1 of the Federal Constitution places 2 substantive limitations on both federal and state legislatures. 1. No ex post facto laws, and 2. No bills of attainder. So, 1. The Constitution expressly prohibits ex post facto laws. The Supreme Court has defined an ex post facto law as one that operates retroactively to make criminal an act that, when done, was not criminal. 2. Aggravate a crime or increase the punishment. 3. Change the rules of evidence. And 4. Alter the law of criminal procedure. And this is an or. So this is a disjunctive definition. Okay, no bills of attainder. Number 2. Bills of attainder are also constitutionally prohibited. A bill of attainder is a legislative act that inflicts punishment or denies a privilege without a judicial trial. Although a bill of attainder may also be an ex post facto law, a distinction can be drawn in that an ex post facto law does not deprive the offender of a judicial trial. G. Interpretations of criminal statutes. 1. Plain meaning rule. 2. Ambiguous statutes strictly construed in favor of defendant. And 3. Expressio unis, exclusio alterius. And let's get into the plain meaning rule. When the statutory language is plain and its meaning clear, the court may give effect to it, even if the court feels that the law is unwise or undesirable. An exception to this rule exists if the court believes that applying the plain meaning of the statute will lead to injustice, oppression, or an absurd consequence. And 2. Ambiguous statutes strictly construed in favor of defendant. The rule of lenity requires that an ambiguous criminal statute must be strictly construed in favor of the defendant. Ambiguity should be distinguished from vagueness. An ambiguous statute is one susceptible to one or more equally reasonable interpretations. A vague statute is one that is so unclear as to be susceptible to no reasonable interpretation. And for reasons that you cannot convict a person of a criminal offense without certainty beyond a reasonable doubt is where the rule of leniency gets its roots. I made that up. Expressio unius exclusio alterius. According to this maxim, the expression of one thing impliedly indicates the intention to exclude the other. I knew that. Example. A criminal statute defines bigamy as the act of remarriage by one who has a living spouse. The statute expressly provides an exception for one whose spouse disappeared more than 7 years before. Can a person remarry if the spouse has been gone for less than 7 years, provided he or she believes in good faith that the spouse is dead? More jurisdictions answer no. The fact that the statute provides one exception impliedly excludes all others. 4. The specific controls the general. The more recent controls the earlier. Since that's a riddle, the specific controls the general, comma. The more recent controls the earlier. Okay. If two statutes address the same subject matter but dictate different conclusions, the more specific statute will be applied rather than the more general. And likewise, the more recently enacted statute will control an older statute. Example, if one statute prohibits all forms of gambling and the other permits charity-sponsored raffles, the latter will control a church raffle. 2. A 1980 statute banning advertising of cigarettes will govern a 1975 statute providing a limit on advertising expenditure by cigarette manufacturers. Effective repeal. At common law, in the existence of a saving provision, the repeal or invalidation of a statute operates to bar prosecutions for earlier violations, provided the prosecution is pending or not yet underway at the time of the repeal. However, a repeal will not operate to set free a person who has been prosecuted and convicted and as to whom the judgment has become final. A. Saving provision. Many of the new comprehensive codes include a provision to the effect that crimes committed prior to the effective date of the new code are subject to prosecution and punishment under the law as it existed at the time the offense was committed. Merger. Section H. Merger of misdemeanor into felony and no merger among offenses of the same degree. At common law, if a person engaged in conduct constituting both a felony and a misdemeanor, she could be convicted only of the felony. The misdemeanor was regarded as merged into the felony. And B. No merger among offenses of same degree. If the same act or a series of acts that were all part of the same transaction constituted several felonies or several misdemeanors, there is no merger of any of the offenses into any of the others. Modern rule. There is generally no merger in American law with the following limited exceptions. A. Merger of solicitation or attempt to into completed crime. B. Merger of lesser included offenses into greater offenses. And C. Merger of more than one inchoate crime. So for A, a merger of solicitation or attempt into completed crime. One who solicits another to commit a crime, where solicitation itself is a crime, cannot be convicted. Well, here's the here's the definition. One who solicits another to commit a crime where solicitation itself is a crime cannot be convicted of both the solicitation and the completed crime if the person solicited does complete it. Similarly, a person who completes a crime after attempting it may not be convicted of both the attempt and the completed crime. Conspiracy, however, does not merge with the completed crime offense. One can be convicted of robbery and conspiracy to commit robbery. Don't forget the difference between solicitation and conspiracy. Who could possibly do that? Merger of lesser included offenses into greater offense. Lesser included offenses merge into greater offenses in the sense that no one placed in jeopardy for either offense may not later be retried for the other, nor may one be convicted of both the greater offense and the lesser included offense. A lesser included offense is one that consists entirely of some, but not all elements of the greater crime. This rule is sometimes labeled a rule of merger, but is also clearly required by the constitutional prohibition against double jeopardy. And so, examples are given, but it's quite obvious that you can't be charged with murder and manslaughter for the same death. C. Murder of more than one inchoate crime. Under the Model Penal Code, a defendant may not be convicted for more than one inchoate crime when his conduct was designed to culminate in the commission of the same crime. C. Developing rules against multiple convictions in parts the same transaction. For parts the same transaction. That just doesn't sound like a sentence. 3. Under the merger clause. Developing rules against multiple convictions for parts of same transaction. Many jurisdictions are developing prohibitions against convicting a defendant for more than one offense where the multiple offenses were all part of the same criminal transaction. In most states, this is prohibited by statute. In others, courts adopt a rule of merger or of double jeopardy to prohibit it. And last one in section 1 is no double jeopardy if statute provides multiple punishments for a single act. Imposition of cumulative punishments for 2 or more statutorily defined offenses specifically intended by the legislature to carry separate punishments arising from the same transaction and constituting the same crime does not violate the double jeopardy clause prohibition against multiple punishments for the same offense when the punishments are imposed at a single trial. So, example, D robs a store at gunpoint. D can be sentenced to cumulative punishment for armed robbery and armed criminal action against under a use a gun, go to jail statute.